One, my lord, I will not read this because they have not agreed with this attack. If my lords kindly turn over the page, my lords, they say 15 is not violated. Let me straight away go to para 10. My lords have para 10, my lord. In the alternative, it is urged that district-wise distribution violates Article 14 of the Constitution because it denies equality before the law or equal protection of the laws, in as much as such allocation of seats may result in candidates of inferior caliber being selected in one district, while the candidates of superior caliber cannot be selected in another district. Exactly what your lordships are seeing in this case. Somebody with a higher mark is going out and somebody with a lower mark is getting it. Let me read further.
No, this can happen.
Yes, sir.
This can happen if you have one combined selection.
For one district.
No, for all the districts.
Correct.
You have combined selection.
Yes, sir.
But in the advertisement,
yes,
you
sir.
point out
yes, sir.
that you can apply against this district.
Correct.
One can apply against this district. Then the selection process for that district is confined to one selection process.
Correct.
Though your selection process
correct.
is combined.
Correct.
So this can happen.
Yes, sir. Let me read further.
Yes.
Incident 1 is so and so. It has not been denied on behalf of the state that such a thing cannot happen, though there are no statistics available in this behalf because the mark sheets were all destroyed after the interviews. Para 11. The question whether district-wise allocation is violative of Article 14 will depend on what is the object to be achieved in the matter of admission to medical colleges. Here, your lordship will read it, my lord, for selecting teachers to teach. The object of selection can only be to secure the best possible material for admissions to college, subject to the provision for socially and educationally backward classes. So this is the rider. Further, whether selection is from the social and educational backward classes or from the general pool, the object of selection must be to secure the best possible talent from the two sources. If that is the object, it must necessarily follow that the object would be defeated if seats are allocated by districts allocated district by district. It cannot be and has not been denied that the object of the selection is to secure the best possible talent from the two sources so that the country may have the best possible doctors. If that is the object, the argument on behalf of the petitioner appellant that it is the object cannot be possibly be served by allocation district-wise. It is true that Article 14 does not forbid classification, but classification has to be justified on the basis of the nexus between the classification and the object to be achieved, even assuming the territorial classification may be a reasonable classification. The fact, however, that the classification itself is reasonable is not enough to support it unless there is a nexus between the classification and the object to be achieved. Therefore, as the object to be achieved in a case of the kind with which we are concerned is to get the best talent for admission to professional colleges, the allocation of seats district-wise has no reasonable relation with the object to be achieved. If anything, such result will result in many cases in the object being destroyed, and if that is so, the classification, even if reasonable, would result in discrimination in as much as better qualified candidates from one district may be rejected, while less qualified candidates from other district may be admitted from their own two sources, from either of the two sources. So they have gone really one step forward with us to say that such a rule also will be frowned upon. Kindly turn over the page, minutes.
Yes.
Lordship may see, Millard, there is one line which starts after 7-8 lines. We are also satisfied. 9th line, my lord. We are also satisfied. My lordship shall have that line. We are also satisfied that such allocation results in discrimination and there is no nexus between the territorial distribution and the object to be achieved, namely admission of the best talent from the two sources already indicated. We are therefore of the opinion that allocation of seats on the district-wise basis is violation of Article 14, is violative of Article 14. We may add that we do not mean to say that territorial classification is always bad under all circumstances. But there is no doubt that district-wise classification, which is being justified on territorial basis, in these cases is violative of Article 14, for no justification worth the name in support of the classification has been made out. We therefore hold Rule 8 providing district-wise allocation is bad as it violates 14 and therefore we struck it down. So they said that rule said district-wise. They said, look, you are looking for the best talent. So you can't say that district-wise or territorial-wise.
No, but this was whether on the basis of residence of a particular candidate.
Correct.
Here,
Yes.
A resident of Khurda
Yes, my lord.
could give
apply anywhere.
First preference
Yes.
for, say, Malkangiri.
Correct. So what they say is that when you are selecting an MBBS student, select the best talent. Don't restrict it to any district. Here I am saying that if I am selecting a teacher, the students of Malkangiri, Bolangir or Khurda, any matter, any district, they should have the facility of getting taught by the best. That is why you had a CBT exam, otherwise there was no reason. Now, this is one. Kindly see one more judgment. Now, this is Radheshyam Singh, where a zonal consideration was being considered. People were applied, so they said, okay, for A zone, these candidates. Kindly see para 2 minutes. May I see, Lordship, may kindly see para 3 at page 62. This is, my Lord, 1997, volume 1 SCC, page 60. And if my lords are graciously pleased, my lords, kindly turn to paragraph 3, my lords. My lords are para 3.
Yes.
According to this said advertisement, recruitments were to be made zone-wise on the basis of a separate merit list drawn from each zone in respect of the candidates who appeared at the centers within the same zone. The relevant portion of the said advertisement, which relates to zone-wise process of selection of candidates for the said post, as stated in para 16 of the advertisement, for ready reference is reproduced. Your Lordship may skip all that minutes and kindly come to paragraph 7. This is just above placitum H.
Yes.
The question therefore arises for consideration is whether such a selection based on zonal basis would be permissible or would it violate the constitutional guarantee enshrined under 14 and 16 of the Constitution of India? This is the question, my lord, the Honorable Supreme Court poses for itself. Now, paragraph 8. It is needless to emphasize that the purpose and object behind holding a recruitment examination is to select suitable and best candidates out of the lot, and such an object can only be achieved by making a common select list of successful candidates belonging to all zones. On the other hand, if zone-wise selection is made, then various candidates who appeared in some of the zones and secured more marks than those who secured from other zones would be deprived of their selection, resulting into great injustice and consequent discrimination. Thus, there can be said to exist no nexus between the aforesaid process of zone-wise selection and the object to be achieved, that is selection of the best candidates. That being so, the process of selection envisaged in para 16 of the advertisement in question and reproduced in the earlier part of the judgment would lead to discriminatory results because adopting the said process, zone-wise selection would result in devaluation of merit at the selection examination by selecting a candidate having lesser marks over the meritorious candidate who has secured more marks, and consequently the rule of equal chance for equal marks would be violated. Such a process would only be against the principles enunciated in Article 14 and 16 of the Constitution, but it also but it also result in heartburning and frustration amongst the young men of the country. The rule of equal opportunity, lordships have read it, and then I need not trouble your lordship. But one more judgment, and I'm done. Well, this is 2021 4 SCC 542, and there is a concurring judgment.
Which volume?
My Lord, this is 2021 volume 4 SCC 542.
Yes.
This is Saurav Yadav and others versus State of Uttar Pradesh. And if my lords are kindly pleased, this is Justice Bhatt's concurring judgment. And it is at page 590.
Yes.
Paragraph 38 and 39. The second view is thus neither based on the authoritative pronouncement of this court, nor does it lead to a situation where merit is given precedence. Subject to any permissible reservation, either social, vertical, special, opportunities to public employment and selection of candidates must purely be based on merit. Any selection which results in candidates getting selected against open general category with less merit than the other available candidates will certainly be opposed to the principle of equality. There can be special dispensations when it comes to candidates being considered against seats or quota meant for reserved categories, and in the theory, if it is possible that more meritorious candidates coming from open general category may not be selected. But the converse can never be true and will be opposed to the very basic principles which have all the while been accepted by this court. Any view or process of interpretation which will lead to incongruity, as highlighted earlier, must be rejected. The second view thus, para 39, the second view thus will not only lead to irrational results, where more meritorious candidates may possibly get sidelined, as indicated above, but will of necessity result in acceptance of a postulate of open/general candidates or reserve candidates other than those coming within the vertical. So I am relying on the first line, and that's it, perhaps. I'm grateful to your lordship. Please.
Lordships, we've been greatly benefited with the Honorable AG's argument, not much to add except this, that which in fact fell from your Lordship's mouth also, is that this was never meant to be actually a district-wise or a residence-based recruitment.
See, there could have been two results. One, purely based on the merit for the entire state, based on preference also. And then that one merit list would have been bifurcated, divided, again based on preference. So there would be no difference between the first merit list, the candidates in the first merit list, and those selected, those divided, bifurcated from them based on preference, district-wise. Am I clear?
Lordships.
So only a separate merit list, like it's a kind of allocation to districts.
Lordships.
So one from one combined merit list, you are allocating, the state is allocating different districts.
Yes, and I think one thing which I wanted to bring to your Lordship's notice is this, that each one of them was actually allowed to participate for each and every post, irrespective where it is placed. That's very important. All that probably the state did, instead of state preferring, you are allocated this or that, allowed that you make your preference or your first or second preference wherever you want to be placed according to the marks that you secure. So state never wanted to do away with the merit issue. So that's very important. Because when it happens, if it was completely district based, then in fact they would have also asked for a residence certificate or something. That was not at all the case here. So
no, residence was never the criteria.
Never the criteria.
Preference had some criteria.
And according to your preference, you do get allocated. That's all. But this preference was never meant to absolutely not allow people who are higher up in the merit to go away. Because as I last time also submitted, the extreme of that argument would be that only because I preferred, I'll get a seat even if I secure zero. But that's possibly not. And I think that would be a very compromising situation vis-a-vis the state, and state would vis-a-vis the districts, which state would never want to do. Especially if you want to maintain a particular standard of education throughout the state. That's all would be to look at the entire thing from that perspective. That's all I would add. Otherwise, everything has been covered by our honorable.
May I be permitted to supplement Land Advocate General's? So I'll only supplement by some 2-3 judgments. But one thing, as your lordships pointed out, so far the merit of the case is concerned, in fact, on 10/9/2023, which was placed by the Land Advocate General, the candidates will be selected on the basis of the marks secured on the CBT computer-based test examination. This was circulated about the candidate, and candidates are aware before the process of selection was started, before the CBT exam.
There is another aspect.
Sir,
The notice, the advertisement was not contrary to any provision under the resolution.
on the reservation.
Under resolution.
Oh yeah, resolution.
Resolution. So that the process which was adopted was not in conflict with
Yes, sir.
any
Yes.
provision under the resolution 8.2, 8.3,
Right,
whatever.
right. So therefore, 8.2 read with this notice dated 10/9/2023 makes it very clear. The candidates will be selected on the basis of the marks secured in the CBT computer-based test examination. That's all. And you also already read 8.2 and 8.3. What comes to my mind?
And the district-wise posts were not advertised.
No, sir. According to my submission, 8.2 is the preparation of the merit list through the computer-based test, and the allocation is 8.3, if I have correctly understood. And the what comes to our mind that here is a question of merit and the preference of the district. This comes two things. I have brought two judgments. Here is a case. AI 2006 Supreme Court. I don't want to again further add something which the Advocate General already clarified to lordships, and they have given also illustrations. And this judgment, if lordships will come to where the merit and the preference is there, particularly which will be preferred. Lordships look to paragraph 4. Paragraph 4. To appreciate the real controversy in perspective, it is necessary to notice the requisite qualification mentioned in the advertisement as per the requirement of Rule 8 of Uttar Pradesh Homeopathic Medical Service Rule 1990. These are the academic qualifications, the entry of the recognized degree in homeopathic, that is the minimum qualification. But you also see the bottom. It will be noticed from the above quoted rules that in addition to the requisite qualification, a proviso has been added, inverted comma, preference will be given to the degree holders. The real controversy starts from the proviso that preference will be given to degree holders. Then also straightway come to the last but one page, the judgment in 2003 BB Commission versus YBBR Srinivasan that has been quoted. Let me read that quotation, then I'll take the to paragraph 12. The word preference.
Which paragraph?
That is paragraph 11.
11.
Just above paragraph 12.
Yes.
The quotation. The word preference, in our view, is capable of different sets of meaning, taking color from the context, purpose, and objects of use on the scheme of things envisaged. Hence, it is to be construed not in isolation or detached manner, ascribing a meaning of universal import for all contingencies capable of an invariable application. The procedure for selection in case involves a qualifying test, a written examination, an oral test or interview, and the final list of selection has to be made on the basis of the mark obtained in them. The suitability and all around merit, it has to be adjudged in that manner only. That justification could be there for overriding all this merely because a particular candidate is in possession of an additional qualification on the basis of which a preference has also been envisaged. The rule do not provide for separate classification of those candidates or apply different norms of selection for them. The preference, inverted comma, envisaged in the rule, in our view, under the scheme of things and contextually, also cannot mean an absolute en bloc preference akin to reservation or separate and distinct method of selection for them alone. A mere rule of preference meant to give weightage to the additional qualification cannot be enforced as a rule of reservation or rule of complete precedence. Such a construction would not only undermine the scheme of selection envisaged through the Public Service Commission on the basis of merit performance, but also would work great hardship and injustice to those who possess and the required minimum educational qualification with which they are entitled to compete with those possessing additional qualification to and demonstrate their superiority merit-wise and their suitability for the post. It is not to be viewed as a preferential right conferred even for taking up their claims for consideration. On the other hand, the preference envisaged has to be given only when the claim of all the candidates who are eligible are taken for consideration and when anyone or more of them are found equally positioned by using an additional qualification is a titling factor in their favor vis-a-vis other in the matter of actual selection. Then paragraph 12. In the instant case, the requisite academic qualification for the post of homeopathic as prescribed in the advertisement was recognized a degree in homeopathy or a recognized diploma in homeopathy. A proviso has been added that the preference will be given to the degree holders. This would mean that a recognized diploma in homeopathy prescribed in the advertisement is also a required minimum educational qualification with which they are entitled to compete with those candidates possessing the degree. The word preference would mean that when the claims of all candidates who are eligible and who possess the requisite educational qualification prescribed in the admission are taken for consideration, and when one or more of them are found equally positioned, only the additional qualification may be taken as a titling factor in favor of the candidate vis-a-vis others in a merit list prepared by the commission. But preference does not mean en bloc preference irrespective of inter se merit and suitability. This is one. Another.
So there is difference between the preference which has been dealt with in this judgment and the preference in the present selection process.
Yes.
There the preference, the selection body gives.
Right.
The state gives.
The
State gives that preference. Here, the preference is to be given by the candidate.
Yes, sir.
For the purpose of allotment of a district. This is the difference between. But yes, the law, the crux remains that merit has to be given.
Merit has to be given. That is what my entire.
But the preference in this and preference.
Is absolutely correct. Absolutely correct. There the state has done it or the employer has done it. Here the candidate themselves have done it.
Have to prefer. They have 10 choices.
Yes, sir.
Which will you prefer?
Right, sir. Right. So now the question is, sir, the merit. Merit cannot be sacrificed. And I don't know, possibly it is for the state. So far 8-2 is concerned, they have prepared a list. So far as these 4 candidates who have approached this honorable court, whether their names at all found place in that merit list that which was prepared in terms of Rule 8-2, I don't think. And even if their names found place, even if their name must be below that list. So they cannot be compared to a person. But I just give an example. Suppose the district Khorda, there are only 10 posts. And 30 candidates have given their preference to Khorda district. But it is the employer's duty, the state duty, to give those candidates according to their preference. They will give the other candidates which cannot be accommodated as per their merit to other district. So therefore, under no circumstances merit can be sacrificed.
No, there can be another example.
Sure.
I don't know this thing in demography and the economic conditions. But suppose Kalahandi.
Yes, sir.
So for Kalahandi, the first preference is met by, say, 20 candidates only out of 1 lakh. So,
Right.
can it be a situation that those 10 candidates will have to be selected for Kalandi, whatever their performance is?
Absolutely, absolutely. Your Honesty is correct. Correct. That is the position. Correct. So therefore, the has to be the merit list cannot be ignored. So far as the post judgment is concerned, what they have prepared, I found these 4 candidates, even including the petition number 1, the private opposite party, they have secured the marks much below the marks secured in the last candidate in any other districts. So the category 2. So for the Malcolm, in that case, if the honorable single judge judgment is accepted, that means a candidate who has secured 146 has to be selected, and a candidate who has secured 176 has to be ignored. That means in between 2, the merit has to be sacrificed. That is what another judgment I'm just giving. I close my argument. This is also 1989 Supreme Court page 1194, paragraph 14. I think an advocate general cited one judgment also that that's the intelligible differential so far as this district is concerned. That paragraph 14. Let us now examine the question of college-wise institutional preference, paragraph 14. From the point of view of Article 14 of the Constitution, by the impugned rule, the classification.
You are reading which paragraph?
Paragraph 14. Paragraph 14. 1-4.
Yes. Please.
Let us now examine the question of college-wide institutional preference from the point of view of Article 14 of the Constitution. By the impugned rule, a classification has been sought to be made with the students of each particular college passing their MBBS examination from that college to the exclusion of all other students obtaining their MBBS degree from the other colleges. In order that a classification is a permissible one within the meaning of Article 14 of the Constitution, 2 tests have to be satisfied. Namely, 1, that there is an intelligible differential which distinguishes persons grouped together from those who are left out of the group. 2, that there is a rational nexus to the object sought to be achieved by the impugned rule. The object sought to be achieved by the impugned rule is obviously to prefer merit for the postgraduate course and to exclude less meritorious candidate. Then you also kindly come to paragraph 15, middle portion. Paragraph 15, middle portion. Thus, although you also from paragraph 15, 1, 2, 3, 4, about 8 lines from the top. Thus, although Dr. Anjali so-and-so and Dr. Sumit so-and-so secured more marks than the student admitted in the postgraduate course in so-and-so in said GS Medical College, except the said Dr. Ganapati Sawan, they are refused admission in view of the college-wise institutional preference. Similarly, in respect of other discipline, many meritorious students could not get admission even though they secured higher marks than those admitted in the postgraduate degree course by virtue of the impugned rules. Thus, there is a patent discrimination in as much as the students obtaining lesser marks have been preferred to those obtaining higher marks. There is no intelligible differential for the classification by way of college-wise institutional preference as provided by the impugned rule, distinguishing the preferred candidates in respect of each college from those excluded from such classification. By such classification of college-wise institutional preference, merit has been sacrificed. Far less it has been preferred. When the university is in the same for all these colleges, the syllabus, the standard of examination of a skip over, last line. In such circumstances, college-wise institutional preference cannot be supported, and it has already been noticed that this court has not approved of such preference at all. These are so far the merit is concerned. Well, I have already argued before the law and advocate general has argued. Well, so far as the implication of party is concerned, I have already argued. One judgment I will show you assist. Even the Honorable Supreme Court has gone to an extent that if a person is a necessary party but has not been implicated as a party, then that judgment is ab initio void. That is null and void. That is a judgment Kulwant Singh's case, which has been referred to by a division bench of where Justice Sharangian just that judgment I'm not giving, but the Supreme Court judgment I'm giving at paragraph 39 and 40. Yes. Yes.
That is order in SLP. Kulwant, right?
No, it is yes, but Supreme Court in civil appeal. In a civil appeal, yes. Civil
It's not
appeal.
in the order in SLP, that is referred. Judgment.
No, this judgment, if you are super look to, just I'm showing it. Para 39. Para 39.